Okay, now government has backtracked slightly on its controversial employment equity targets. This comes after a settlement was reached with trade union Solidarity about certain provisions. Now, the Employment Equity Amendment Act includes numerical targets for specific industries, sectors and provinces. Part of this agreement, we understand, is that no penalties or disadvantages will be imposed on employers who can demonstrate reasonable grounds for non-compliance. There are a number of provisions, including the scarcity of qualified candidates from designated groups, adverse business economic circumstances, among others. Let's discuss the significance of this with employment law specialist at Webber Wentzel, Lizle Louw. Lizle, good afternoon. Welcome to today, and thank you very much for your time. Let's start first with an overriding question before we delve into some of the details. Does this settlement agreement between trade union Solidarity and the government change anything at all in terms of what's envisaged in the new Employment Equity Act?
Thank you, Dan. Whilst the content of the settlement agreement is not new, in other words, it's not anything that designated employers would not have seen before, it provides welcome certainty on certain aspects contained in regulations that have been issued in circumstances where the validity of the regulations is in question. For instance, in the 2018 regulations, there was a list of justifiable grounds for non-compliance with employment equity targets. That list of justifiable reasons appear as is in the settlement agreement. The validity of the 2018 regulations is in question because it was issued before the Employment Equity Amendment Act is actually effective. But now, with the settlement agreement, there is a source where designated employers can go to and use for those aspects that are in the regulations, which is uncertain at the moment. So there's definitely value in the settlement agreement. But apart from the content of the agreement, I think it signifies and it signals government's intention to apply the employment equity measures as envisaged in the Act and regulations in a fair and equitable manner, which is good.
Okay, so practically, just break it down to details. There has to be reasonable grounds of non-compliance, and just break them down for us.
Certainly. The list is insufficient recruitment opportunities, insufficient promotion opportunities, mergers and acquisitions, transfers of business, which means, for instance, you're an employer, you acquire a business with a certain set of employment equity figures which you inherit. And if that does not meet the set targets, that could be used as a justifiable reason for non-compliance with the targets. There are also things like CCMA awards and court orders, and then things that could impact on economic circumstances, most recently COVID.
So we have the law normally, and then we have regulations that affect the law, that people must act accordingly. Should employers anticipate a change, an update or amendment of those regulations after this settlement agreement between Trade Union Solidarity and government?
Yes, Dan. In fact, it is recorded in the settlement agreement that this agreement will be published as part of 2023 regulations. So there must be an updated regulation. It's also recorded that the settlement agreement is in settlement of the Labour Court matter that Solidarity launched. So the status of this agreement, it will become part of the regulations. It will also be a court order. So yes, employers must expect new regulations or updated regulations.
So this would mean that when employers develop and agree on their, normally it's about 5 years, their 5-year employment equity plans, they will have to take into account the settlement agreement.
Yes, as I said, which is very welcome because it now is a source of factors that they can use in developing their employment equity plans. Some designated employers have employment equity plans valid for 1 year, for 2 years, for longer. The 5-year relevance is that once the Amendment Act becomes effective, designated employers will have 5 years from that date to comply with the new sector targets.
Okay. I mean, the population in the country is dispersed in a way that some areas have a predominance of one racial group than the other. Those kind of factors will be taken care of under this settlement agreement.
Well, not in terms of this settlement agreement, but what has happened in the 2023 regulations, the sector targets were issued, and there are sector targets nationally and provincially, and designated employers must then choose which of those sector targets they are going to comply with. They can't mix and match. They need to choose one and then strive to compliance for either the national targets or the provincial targets.
Okay. Now, you know, there's always been this debate in our country around affirmative action, and some people even arguing that it's a racist policy and it's not helping. But there are general principles that govern the lawful application of employment equity to redress the imbalances of the past. Does this settlement agreement, in your view, Lizle, help us to really address the past or redress the past imbalances in terms of job opportunities to make sure there is equity?
Yeah. So, yes, affirmative action is necessary to address the imbalances of the past. It is also written into our Constitution, in specifically Section 9 with the right to equality. And affirmative action, our courts have been cleared, is not an exception to the right to equality. It restores equality. So it is necessary. So the settlement agreement codifies a lot of factors that would help employers move towards meeting targets. A target cannot be set absolutely because of all the varying factors that are present. It's just a fact of life, and we've gone through that list now. So where the settlement agreement helps, it provides guidelines for employers how to get there. And it sets reasons for which employers can forward if they don't get there. And I think this list of reasons is reasonable, and I think it's objective, but it doesn't take away from the fact that employers will have 5 years to meet the sector targets. And that is, of course, the prize. The settlement agreement just helps them get there.
Yeah, but does it make room for employers, what can I, to take some gaps and say, well, reasonably we can comply? Or is this a settlement agreement supplementing or complementing the amendment that itself and closes all doors where people might just find excuses not to implement affirmative action?
Yeah. A lot of people will say that there should be no justifiable grounds for non-compliance. And a lot of people will interpret the fact that there is a list of justifiable grounds as gaps for employers not to comply. But I think it's not realistic in today's economy and in today's realities, business realities, to say that there must be absolute compliance or not. There will always be exceptions or reasons, sometimes, whilst it's not ideal for some designated employers who cannot meet the sector targets. And the balance is then to have a list like is contained in the settlement agreement that will be published as part of the regulations that provide certainty on exactly what reasons could be acceptable for non-compliance so that it's not a free-for-all. And remember, there are consequences for non-compliance. So whilst this list of factors exist that could justify non-compliance, if it is not accepted ultimately, there's still penalties in the form of fines and not being able to do business with government, and so on.
Okay, Lizle Louw, thank you very much for your time and explanation this afternoon. She's, of course, an employment law specialist at Webber Wentzel.